Thank you. We'll hear from Senator Cornyn, and then we will go to Mr. Grindler.
Thank you very much, Mr. Chairman. Welcome, Mr. Grindler. Mr. Chairman, I feel compelled to attend this hearing because I think that the Department's decision in this matter should once and for all put to rest any notion that Jay Bybee, John Yoo, and their associates deserve anything other than the thanks of a grateful nation for their service. For too long, men and women have dedicated their lives to protecting our country in the wake of 9/11, have been slandered, harassed, and threatened with professional sanctions and even criminal prosecution. Whether we're talking about Justice Department attorneys or CIA field agents, these men and women have sacrificed more than we can comprehend to keep the American people safe from another terrorist attack. Of course, last week, after an investigation that spanned 5.5 years, Judge Bybee and Professor Yoo have been cleared of any professional misconduct. Regrettably, a criminal investigation ordered by the Attorney General is still underway into the CIA interrogators who relied in good faith on this legal advice. This criminal investigation, I believe, is likewise unnecessary. It's unnecessary because federal prosecutors in the Eastern District of Virginia have already reviewed an exhaustive number of cases referred by the CIA's Inspector General and military criminal investigators. Think about that for a moment. The Attorney General has ordered a criminal investigation into interrogations conducted within parameters of legal advice provided by the Justice Department, legal advice that, regardless of one's policy preferences, has been judged by career officials in this Justice Department to have been given in good faith. The President and the Attorney General should bring the investigation of these CIA personnel who relied in good faith on this legal advice to close immediately. But we're here, of course, to discuss the Office of Legal Counsel memos. Despite the Department's decision holding that Judge Bybee and Professor Yoo committed no professional misconduct, some on the far left continue to call on the Attorney General to prosecute them for rendering good faith legal advice. To be sure, the legal advice offered by the OLC attorneys addressed difficult and novel and close questions surrounding the fine line where aggressive interrogation becomes unlawful torture. But in a democracy committed to the rule of law, we must resist the temptation to criminalize policy differences and good faith differences on legal matters. Prosecuting the former administration's lawyers might be popular with some of the president's most left-wing supporters, but I am confident that such prosecutions would threaten the professional integrity of government lawyers, the country's ability to gather intelligence and fight the war on terrorism, and the rule of law itself. Let me just provide some context, which I think the Margolis memo took into account, which I think is important and which we've forgotten. I think too many of us got forgotten these many years after September the 11th, 2001. The lawyers who offered their legal advice on the CIA's enhanced interrogation techniques were working at an extraordinary time in our nation's history. 9/11 was less than a year in the past, and reliable intelligence indicated that al-Qaeda was planning follow-on attacks. The CIA had several top al-Qaeda agents in custody, and these terrorists revealed some useful information, but many of them had simply stopped talking. CIA interrogators were certain that these al-Qaeda agents had additional information about plans to attack America and our interests overseas. Of course, I recall the tremendous bipartisan pressure there was on our intelligence community to increase its counterterrorism efforts to gather actionable intelligence and prevent the next terrorist attack. The House and Senate Intelligence Committees had concluded that the intelligence community did not, quote, demonstrate sufficient initiative in coming to grips with new transnational threats, close quote, in the days before 9/11. So the CIA wanted to know what it could legally do in order to demonstrate sufficient initiative in coming to grips with new transnational threats, just what Congress indicated they wanted. So they wanted to know if they could legally use interrogation techniques that our own military uses in survival, evasion, resistance, and escape or SEER training, including waterboarding. But the interrogators did not simply start using these techniques. Instead, they did the right thing, and they asked their superiors, they asked the lawyers at the Office of Legal Counsel for advice about the advisability and legality of these techniques. So the issue was raised and debated by lawyers within the CIA, along with those in the White House and the Department of Justice's Office of Legal Counsel. I think you can't read these memos without seeing that there is an attempt to do what every lawyer does when presented with a novel and difficult legal question, and that is to do the research, try to offer opinions on both sides, and then ultimately you have to reach a conclusion. And I think they earnestly wrestled with these difficult legal questions. They called the question regarding the legality of waterboarding substantial and difficult. And it's no doubt a difficult question, one they sought to resolve to the best of their ability, as the department concluded last week. Today's hearing comes after the department's decision that has found no grounds for charging these two men with professional misconduct. But from listening to some of the responses to the conclusion of Mr. Margolis, you might think they had been found guilty of professional misconduct, not exonerated of professional misconduct. Perhaps the OPR investigation itself should be inquired about. I hope the witness, Mr. Chairman, can talk to us about the Office of Professional Responsibility's failure to follow its own standards. I realize the witness wasn't there then, but I'd be interested to know what the Department of Justice intends to do to correct what Mr. Margolis said was a failure of OPR to follow its own standards. And Mr. Margolis also pointed to the OPR's failure to cite a violation of a known standard of conduct, risking the likelihood, which apparently occurred here, that there would be a subjective standard applied rather than one that lawyers could discern and find out and CIA interrogators could follow. And then, of course, there was, as I mentioned, OPR's failure to take into account the circumstances that existed in the aftermath of September the 11th, when these individuals charged with protecting the American people were in good faith trying to prevent the death of other innocents, such as we saw at the Pentagon and we saw at the World Trade Center on September the 11th. And then, as Senator Sessions mentioned this, the leaks to the media, which have done irreparable damage to the reputations of these two men who've now been found not guilty of professional misconduct, is just shameful, and I hope we get to the bottom of it. Thank you.